Hello everyone, welcome to Legal Darshan. In today's video, we are going to look at the case of Sukhpal Singh Khaira versus the state of Punjab. It is listed at number 69 in the list of AOR leading cases. Now, this case basically deals with two questions that the five judges bench is referring in this case. The bench comprised of Justice Abdul Nazir, Justice Gawai, Justice Bopana, Justice Rama Subramanian, and Justice Nagratna. Now, the five judges bench in this case is basically giving the guidelines as to how the power under Section 319 of the Criminal Procedure Code can be invoked. Okay, what Section 319 is? Okay, now, Section 319 in the CRPC is titled as Power to Proceed Against Other Persons Appearing to be Guilty of Offense. Okay. Now, it deals with adding another persons as the accused in an already listed case. Okay, so where in the course of an inquiry into a trial of an offense, it appears from the evidence, okay, that any person not being the accused has committed any offense for which such person could be tried together with the accused. Okay, so in evidence, if it is found, okay, that a person who has not been made accused, okay, he can also be tried along with the accused. For example, an offense has been committed, there is a person A who is accused. Okay, now during the trial the evidence so proved that there is a person B who should also be tried together with the accused. Then Section 319 is invoked and the court has power, the session court or the trial court has power to proceed against such person for the offense which he appears to have committed. Okay, where such person is not attending the court, he may be arrested or summoned as the circumstances of the case may require for the purpose aforesaid. Clause 3 says any person attending the court, although not under arrest or upon a summon, may be detained by such court for the purpose of the inquiry into a trial of or the offense which he appears to have committed. Okay. Um, there can be a detention if a person is not complying with the demand of inquiry or trial as well. And clause 4 says where the court proceeds against any person under subsection 1, okay, any person who is impleaded as an accused, who is impleaded as a person who can be tried jointly with the accused in the ongoing trial, then in that case the proceeding in respect of such person shall be commenced afresh and the witnesses be reheard. And second, subject to the provision of clause A, the case may proceed as if such person had been an accused person when the court took cognizance of the offense upon the when the court took cognizance of the offense upon which the inquiry or trial was commenced. Okay, so Section 319 is basically looking at that when in evidence, it appears from the evidence that a person who is not already accused can be also tried together, then the power is invoked under Section 319 of the Constitution of India. Okay, so now when we come back to the case, because the case is majorly dealing with Section 219. Okay, so now basically, if we look at the brief facts of this case, okay, so this person, Sukhpal Singh Khaira, he is a political leader in Punjab belonging to the Congress party. A massive narcotics and money laundering racket was unearthed against him, and he was booked under the NDPS Act as well as the Arms Act also. Okay, now initially what happens, Khaira, this leader Sukhpal Singh Khaira, he is not named in the FIR, but later his name crops up in the supplementary investigation reports, basically alleging for against his links with the accused, which were already being tried. Okay, now based on that, he was summoned by a trial court under Section 319 of the CRPC in 2018. Now the main question, because there is an allegation that it was a political vendetta, that it was a political persecution, the court is also looking into Section 319 because at prima facie there was no evidence, which he is challenging that there is lack of evidence that is supporting the contention that he should also be tried as an accused in the matter, invoking the jurisdiction under 319 of the CRPC. Okay, now basically Supreme Court is dissecting the issue herein. Okay, so first issue that comes before the court is that when do we find that a trial is completed? Okay, now the first finding in this case that the Supreme Court is giving in the case of Sukhpal Singh Khaira is that a criminal trial is not complete on the pronouncement of the judgment of conviction of the accused, but it completes with their sentencing. Okay, the court is saying that in a criminal prosecution, the conclusion of a trial, if there is a conviction, now we need to understand sentencing happens only when there is conviction. So the court is saying that once there is a trial concluded, we can only call a criminal trial concluded if the judgment pronounces conviction, and the judgment to be is considered to be complete only when the sentence is imposed on the convict. On the convict, exception lies in section 360 of the CRPC, which says that an accused can be released and can be discharged, can be acquitted on the grounds of section 360, which provides the ground for good behavior and surety. Okay, now the court is basically saying that if the convict is not given the benefit of section 360 of the CRPC and he is convicted in the judgment, then in that case, the case concludes, the conclusion of trial happens only when the sentence is imposed on the convict. Okay, so now court is looking at section 232 and 235 of the CRPC. Okay, so the court is saying that when the session court analyzes that there is no evidence to hold one accused. Okay, we are not talking about an accused being impleaded by way of section 319, but a general accused. For example, A murders B and A is being tried. Okay, so either A will now be acquitted under section 232, or A will either be prosecuted and convicted under section 235 of the CRPC. So 232 provides the acquittal. Okay, so acquittal says that session courts, while analyzing the evidence, finds that there is no evidence to hold the accused liable for having committed the alleged offense. The judge is required to record an order in writing and acquit the accused, and if there is nothing further to be done, then on that stage the trial is completed, because there is an acquittal. Okay, now there is no conviction, so the question of imposing sentence does not comes into account. But when we look at section 235 of the CRPC, and the subsection 2 provides that if the accused is convicted and the benefits of good behavior as surety are not given to him in the exercise of section 360 of the CRPC, now what happens is that the question of sentence is to be heard and the sentence will be imposed on him in accordance with the provision of law. Okay, so now the court observes that once the judgment of conviction is given, the trial shall not be deemed to be completed until and unless the punishment, the sentence is imposed on him. So the session judge, okay, the trial judge, he is required to exercise the application of mind on the evidence that is available on the record to, determine the gravity, the severity of the offense that has been committed, and against which, of course, the accused is found guilty and he is being convicted, and what is the role of accused in order to award the appropriate sentence. So imposition of sentence in case an accused is convicted is the last stage. It is the stage where the trial culminates, the trial concludes against any accused person. Now this is one case, this is one question that Sukhpal Singh Khaira case is basically looking at. Now another lead question that Sukhpal Singh Khaira's case is looking at is the question of the powers to be invoked under section 319 to 19 in the case of accused that is implanted by way of section 319. Okay, now the constitutional bench basically says that power under section 319 of the CRPC is to be invoked and exercised before the pronouncement of order of sentence, where there is a judgment of conviction of the accused. So why did we discuss the first question, that when there is a conviction of accused, okay, when the trial culminates with the imposition of the sentence. Okay, so the court herein is saying, expounding that section 319 powers can only be invoked before the pronouncement of order of the sentence. Okay, because now the trial completes at section 3 at imposition of the sentence in light of section 235 of the Constitution of India. Okay, now why are we determining when the trial is being completed is because 319 says where in the course of any inquiry into or trial thereof. Okay, so we are expanding the scope that 319 can be applied until and unless the sentence is imposed in the case of conviction, which means the trial is thereby going. Okay, so court is saying that 319 can be invoked anytime before there is an there is a judgment, or before there is an order with respect to imposition of the sentence. Okay, in case, of course, where the accused is being convicted. Okay, in the case of acquittal, the power of 319 by the session court should be exercised before the pronouncement of acquittal, before the order of the acquittal is pronounced. Okay, so therefore the summoning order. Okay, now the summoning order under section 319, it should it has to precede the conclusion of trial by imposition of sentence in the case of conviction. And if the order is passed on the same day, it should be examined on the fact and circumstances of the each case. And if such summoning order is passed either after the order of acquittal or after imposition of sentence in case of the conviction, such summoning order under section 319 shall not be sustainable. Okay, now the court is also saying that the trial court has power to summon additional accused which is implanted by way of section 319 when the trial is proceeded in respect of the absconding accused after securing his presence, subject to the evidence recorded in the split up, the bifurcated trial, pointing to the involvement of the accused sought to be summoned. But the evidence recorded in the main concluded trial cannot be the basis of the summoning order if such power has not been exercised in its main trial till its conclusion. Okay, now court herein is basically answering the inquiry that when the trial court has the power to summon a co-accused, summon an additional accused. Okay, how should it be exercising its power? Okay, now also what are the guidelines that the court is issuing with respect to exercise of power under section 319 by the session court? The court is saying that if the number one, because section 319 clause 1 provides that if the competent courts find an evidence or if application under section 319 of the CRPC is filed regarding the involvement of any other person in committing the offense based on evidence recorded at any stage in the trial before passing such order of acquittal or sentence, it shall pause the trial at that stage. Okay, so if the evidence appears so that there is requirement of implanting another person in the trial, then the trial shall be paused at that stage, and it should be before passing the order of acquittal or passing the order of imposition of the sentence. Okay, second guideline that the court gives is that court shall thereupon first decide the court shall thereupon first decide the need or otherwise to summon the additional accused and pass orders thereon. Okay, so court has to pass an order that there is an accused that needs to be implanted, additional accused that needs to be implanted in the trial, and such orders shall be passed in by the court. Okay, the third is if the decision of the court is to exercise the power under section 319 of the CRPC and summon the accused, such summoning order shall be passed before proceeding further with the trial in the main case. Okay, so if the evidence appears that there is a person needs to be summoned, the court will stop the trial proceedings, first summon the other accused, additional accused, and then proceed with the main case. Okay, so if the summoning order of additional accused is passed, depending on the stage at which it is passed, the court shall also apply its mind to the fact as to whether such summoned accused is to be tried along with other accused or he should be tried separately. That is also one question that the courts needs to apply its mind, and court needs to adjudicate in the exercise of section 319 of the CRDC. And if the decision is for joint trial, fresh trial shall commence only after securing the presence of the summoned accused. And if the decision is that the additional accused is needed to be tried separately, an order shall be made, and there will be no impediment for the court to continue and conclude the trial against the accused who were being proceeded therewith. Okay. Another point is if the proceeding paused, there are total of the 12 guidelines that were passed by the court in this case. Now, if the proceeding paused as in above, as in point number 1 above, it is in a case where the accused who were tried are to be acquitted, and the decision is that the summoned accused can be tried afresh separately, there will be no impediment to pass the judgment of acquittal in the main case. Okay, it will not impede to pass the judgment of acquittal in the main case. Next is, if the power is not invoked or exercised in the main trial till its conclusion, and if there is a split up case, if there is a bifurcated case, the power under section 319 of the CRPC can only be invoked or exercised only if there is evidence to that effect, that there is an involvement of the additional accused to be summoned in the bifurcated trial. Okay, so if the trial splits up and there are evidences that, you know, he is part of the both split up cases, both bifurcated cases, then he will be tried in both. But if there is no evidence, he will only be tried in the main trial, or one of the trials that finds place in the split up or bifurcated case. Okay, now, if after arguments are heard and the case is reserved for the judgment, the occasion arises for the court to invoke and exercise the power under section 319 of the CRPC, the appropriate course for the court is to set it down for the rehearing. Okay, so if you have heard the case is almost over, the judgment is reserved, and then the court finds that we need to invoke the jurisdiction under 319, then the course is that court rehears the matter after, after summoning and after invoking the jurisdiction of 319 CRPC. On setting it down for rehearing, the above-led procedure to decide about summoning, holding of joint trial, or otherwise shall be decided and proceeded with accordingly. Because if you are rehearing the case, you have to abide by the above conditions which are mentioned. Okay. Now, even in such a case, at that stage, if the decision is to summon additional accused and hold a joint trial, the trial shall be conducted afresh and de novo proceedings to be held. That is what the court is holding. And going on to the 12th point, if in that circumstance the decision is to hold a separate trial, in case of a summoned accused, as indicated earlier, the main case may be decided by pronouncing the conviction and sentence and then proceed afresh against the summoned accused. And in case of the acquittal, the order shall be passed to that effect in the main case and then proceed against the summoned accused. Okay. Now, this is amply clear from section 309 that power is on the trial court. The power that is bestowed by way of section 309 to the trial court is to the effect that in the course of inquiry or trial of an offense or based on the evidence rendered before the court, if evidence points out that there is requirement of implanting such an additional accused, then only 319 can be invoked. And if that person has been excluded in the charge sheet and he could not be summoned and tried together with the accused, then only such person can be made additional accusers in the case. Okay, so this is the guideline that is being held in the case of Sukhpal Singh Khaira when the trial culminates, and what are the guidelines for invocation of section 319 of CRPC. The case of Sukhpal Singh Khaira sums it up. This is it for the discussion. I hope the discussion is useful for you. For more such videos, please stay tuned with us on Legal Darshan. Thank you for watching. Stay tuned. Have a nice day.